It seems pretty straightforward to me. The cost of the 24/7 off-duty sworn police officer detail, as well as the cost of the ankle monitor, he said he'll take an ankle monitor too, good Lord, would be incurred by Mr. Williams. So he's going to pay for all of this. Brian Steele, as we know, putting in work always for his guy, Young Thug. He is trying to get Young Thug out of here. And we're going to check out this motion that he just submitted on Tuesday, sorry. And he's trying to get his guy Young Thug bond. So let's see what he's saying and go ahead and get into it without wasting any more time. State of Georgia versus Young Thug, aka Jeffrey Williams. And this is a letter to Judge Whitaker. Renewed motion for bond and brief in support of pre-verdict bond. Comes now, defendant Young Thug by and through undersigned counsel and hereby files this renewed motion for bond and brief in support of pre-verdict bond in the above reference case. In support of this renewed motion for bond and brief, Young Thug shows the below. In the great state of Georgia, unlike other states, for purposes of pre-trial bond analysis, the presumption of innocence remains with the person accused of an offense. Innocent till proven guilty. I like it. Even a capital offense from arrest and even during trial. All right. See Voldemort versus Brand. I don't know how to say that name. That means prior to and during trial, courts view the criminally accused to be innocent and to be innocent of the charges waged against him or her. It has been written that the most fundamental premise of our criminal justice system is that the criminally accused cannot be punished for an offense until the prosecutors prove guilty beyond a reasonable doubt. Well, the court of public opinion would say otherwise, but I get what you're saying. Y'all saw what they did to our guy, Johnny Depp. It's tough out here, man. 2 ABA standards. Okay, they cite that here. We'll keep it moving. Thus, the granting of a reasonable pretrial bond must be preserved. Otherwise, the presumption of innocence secured only after centuries of struggle would lose its meaning. In order to protect our firm foundational belief that the accused is presumed to be innocent prior to finding of guilt beyond a reasonable doubt, the prosecution alone has the burden of persuasion in convincing this honorable court that there are no set of conditions or circumstances that can be ordered to permit Young Thug pre-trial release on bond. All right, and they're saying 2AB, 10.5, and 10DE, D and E. They say the state bears the burden of proving clear and convincing proof that pre-trial detention is warranted. So, I mean, he's saying Young Thug shouldn't have been in jail this long, to summarize. This requires the prosecution to carry the burden of proving by preponderance, we got that one, of the evidence that this honorable court must deny Young Thug's motion for bail outright rather than set bond with conditions of the same in order to ensure Young Thug's presence in the court and protect the community. And Brian Steele saying they haven't shown that. It is so significant to deny Young Thug's pre-verdict bond that the Honorable Supreme Court of Georgia requires the Honorable Court to specifically explain why no bond could be set so our higher courts can evaluate whether there was a flagrant abuse of discretion when reaching that decision. No bond in a RICO case. I'm not sure what the numbers are on that, but I can't imagine it would be pretty common, especially when there's these type of crimes included in it. But hey, again, I'm just a layman. Y'all have to let me know in the comments if that's the case. When considering pre-verdict bond, alleged guilt is extraneous, is completely irrelevant and not considered for pre-verdict bond analysis, as supposed guilt has no place in bail proceedings since Young Thug is presumed innocent. Yeah, there's a couple of factors that you have to take into consideration when determining whether someone could get bond or not. But as Brian Steele is saying here, our Young Thug is saying here, it can't be because you think the person's guilty. Our highest court explained that in a bond hearing, Young Thug bears the initial burden of producing evidence that he would not pose a significant risk to flee the jurisdiction and would return to court when required. Do y'all think that Young Thug would run? I'm not seeing it. Y'all have to let me know what you think in the comments. I don't see Young Thug being a flight risk. He doesn't seem like one that's going to back down, especially with this being his city, with this being done to him in his city, and everything that's going on in the case. I just don't see it. Not to. So here's the other thing that he would have to show: not be a significant threat or danger to the community or any person or property in the community, not to be a significant risk in the community and to commit a felony while on bond, and not to be a significant risk to immediate witnesses or otherwise obstruct administration of justice. Well, so this one's interesting because we know our guy Lil Woody was up there singing. And we know even from this testimony that we've seen from him that he said he was a little nervous about his relationship with Young Thug. So as the prosecution, you may have something here. But going back to what Bruce Harvey said, with everything that's went on here, we don't know what Lil Woody would have said. So this is an interesting point here. I would be interested to see how the prosecution would respond to that. Let's keep it moving. So Brian Steele, now he's going to defend and he's going to show the reasons why Young Thug should have been given bond. Mr. Williams, aka Young Thug, is not a flight risk. I agree. To meet this burden, Young Thug must first present evidence showing his roots in the community, which would include the length and character of residents in the community, which is what I just mentioned. Like this is his life. He lives here. Everything he has is here. Employment status and past history of responding to the legal process. Young Thug was born and raised in Jonesboro, south of Atlanta, Georgia. Since birth in August 1991, Young Thug has maintained his residence in Atlanta, Georgia. Although Young Thug has traveled the globe, he's an artist, has performed his music and artistry in every continent save Antarctica. Thank you for putting that note in there, Brian. Oh, this guy. You gotta love him. He always returns to his homes in the Atlanta, Georgia area. In fact, days before the return of the original indictment and the arrest of Young Thug returned to Atlanta, Georgia from the country of Norway. Young Thug is one of 11 children, and he is the father of 6 children. Oh my gosh. Ages 16, 13, 12, 11, and 9. Okay, we're not going to say they're twins because, you know, there could be another explanation for that. I'm gonna leave Thug alone. All of Young Thug's family lives in Atlanta, Georgia area, including his parents. There is not many among us who has a stronger roots in the community than Young Thug. And he has, I mean, you've got the whole YSL record label that surprisingly wasn't mentioned here, based in Atlanta. You have tons of artists that work, record, release music under YSL. So I mean, that's another point. Young Thug has been working since he was 6 years of age. At age 14, he was recognized and began performing his music for audiences. As a teenager, he had a manager, and within a few years, Young Thug was signed by Atlantic Records and was paid $1 million. Young Thug is currently gainfully employed, tirelessly works at his artistry and other lawful business ventures that include clothing lines, modeling, owner of a successful record label, and various investments. Young Thug has demonstrated a strong history of lawful employment. Young Thug has appeared in court in the past, represented by undersigned counsel Brian Steele, for approximately a decade, to wit, Young Thug's entire adult life. Wow. Yeah, so Brian Steele's a day one, and you can tell from the way he's been defending. I don't even want to minimize it to him saying his client, because I'm sure they have a pretty great relationship behind the scenes. But Yeah, that makes a lot of sense. Young Thug has never missed nor has been late for a court appearance. Young Thug has a history of responding to the legal process. Undersigned counsel is in possession of Young Thug's passport and has permission to surrender this passport as directed by this honorable court for purposes of bond. So they're saying he's not even trying. He's not even trying to flee the country. It's just been 19 months. He wants to get up out of there. Furthermore, when a bonding company writes a bond for this criminally accused, the company takes financial risk in ensuring the criminal's accused presence in court. In the case at bar, Free at Last Bonding Company has agreed to write a bond set by this honorable court, and the representatives of Free at Last Bonding Company are motivated to keep track of Young Thug and prevent any possible flight. Okay, see easy out bonding versus state. Got it. Young Thug intends to present witness to testify at the renewed bond hearing. Specifically, Young Thug's parents, managers, members of his record label, child's friends, business associates, and the like will be present in court to testify and show the support for the granting of pre-verdict bond for Young Thug. Also, just a side note, Young Thug respectfully requests a date certain to argue this renewed motion for bond so that out-of-state witnesses can be present to testify before this honorable court. And, you know, I talked about the court of public opinion. Excuse me. This, in my opinion, is something that we need to address and I think needs to be reminded. I know a lot of us will say we would never be in this situation. So let me just say, put yourself in a situation to where you, by your own actions or not by your own actions, you are having to deal with the court system. You're going to want to be seen as innocent before until proven guilty, right? And a lot of people in the court of public opinion aren't giving Young Thug that right, which it is his right. So you have to look at it from a legal standpoint and from the standpoint of they still have to prove that this man did what he did, even though some may think he did, some may think he hasn't done what he's done, what they're saying he did. But to say he doesn't deserve bond or he shouldn't be out on bond just goes against everything that I think each one of us would want and how we would want to be treated as well. So anyway, I'm done preaching. Young Thug is not a significant threat to the community or any person or property in the community. Young Thug has taken the initiative to secure the commitment of full-time off-duty sworn law enforcement officers to watch his home and secure his home 24/7. Wow. If house arrest is ordered by the honorable court as a condition for pre-verdict bond. So if he has to be house arrest, he said, okay, that's fine. Y'all put me on house arrest, do whatever you need to do, and we can have police officers there all day. Mr. Williams will submit to the condition that any person who would visit at his abode would have to be on an approved list provided to the honorable court as well as the district attorney's office. And if the individual's name is not on this list, that person will be denied entry to his home. I don't see how he didn't get bond. I mean, what else? Why do they need to keep him in jail? Sad, man. Moreover, any visitor will have to consent to being searched physically and electronically by the off-duty sworn police officer. And if the visitor does not agree to consent to search, the person will be prohibited from visiting Young Thug. Young Thug also agrees that any of his text messages, phone calls, emails, and other forms of communication in any matter can be secured and the information provided to this honorable court. Why is he in jail? What is going on? This is another bad look for Fulton County. Why is this man in jail? He said, hey, y'all, I will have a webcam in my house. Y'all can see everything that's going on. And we can live stream it on YouTube. Can I just not be in jail, please? And somehow they said, nope. Gotta sit in jail. Sorry, Mr. Williams. Let's go back. Young Thug also agrees that any of the text messages, phone calls, emails are other forms of communication in any matter can be secured and the information provided to this honorable court if desired if Young Thug was in custody and on a recorded line. It seems pretty straightforward to me. The cost of the 24/7 off-duty sworn police officer detail, as well as the cost of the ankle monitor, he said he'll take an ankle monitor too, good Lord, would be incurred by Mr. Williams. So he's going to pay for all of this. With these parameters in mind, it cannot be said that Young Thug would be a threat or a danger to the community or any person or property in the community. Undersigned counsel will agree to meet with Young Thug at his home to continue to prepare for trial. Seems pretty straightforward. I don't know. The above conditions place Young Thug in custody in his home. Specifically, our General Assembly has provided for the creation of electronic pre-verdict release to assist the sheriffs in alleviating jail overcrowding by creating alternative methods of pretrial release, monitoring, and home confinement. Let me tell y'all this, man. As a music fan, let's go to the music side. Young Thug gets out on bond and drops an album or a song. It's over. It is absolutely over. That would go crazy. I would, man, if he gets out and makes some new music, y'all know I'm a fan of Young Thug's music. That would be absolutely insane. We would forget about Kendrick Lamar. We forget about Drake. We forget all about Eminem and anybody else who's dropping music right now. The music industry would be in shambles. Young Thug would break records like you had never seen. Hey, that's what I want to see, honestly. The legislature found that electronic release, monitoring, and home confinement incorporates modern technology to accomplish various purposes. Therefore, our General Assembly explicitly recognizes that Young Thug's home is a place where he can be confined and restricted in movement for the purpose of electronic pre-verdict release on bond. And see Brown versus State. Ordering Mr. Williams to wear an ankle monitor and to be in total lockdown in his home is the equivalent to custody and confinement and has been deemed lawful confinement without the punishment imposed by the current county jail conditions wrongly imposed on Young Thug. I agree. Young Thug endures the torturous conditions in the county jail, to wit, 22 of 24 hours a day locked into a small cement cell with no contact with any other human except when his counsel visits and in court proceedings. That is terrible, man. Inedible food, living in squalor, ant-infested rooms, and unable to see any activity / movement out of the cell's windows. That's terrible. And if y'all have heard some of the stories about the Fulton County Jail and some of the things that go on in Fulton County, there's people that have, well, I'm gonna leave that one alone, but y'all could do your research. Young Thug is not a significant risk to commit a felony while out on bond. Young Thug is not a convicted felon. A lot of people didn't know that, nor do they care. They just know his name's Young Thug. But I mean, he's truly humble under God, okay? That's what it stands for. So, Young Thug, y'all, give him a break. He is not a convicted felon. This fact alone satisfies this bond factor. Moreover, law enforcement officers executed a search warrant on or about Monday, May 9, 2022, after the arrest of Young Thug on the original grand jury indictment and indictment to search drugs and guns were allegedly located in his home. At the time of this search, there were numerous people at / in Young Thug's home. This is because others live at the home more often than Young Thug, who is at home intermediately, as Young Thug has several homes in the Atlanta area. Thus, Young Thug is not a significant risk to commit a felony while out on bond, especially with the use of the security and other conditions offered above. So I wonder if they're just saying that they still have to prove that this was all Young Thug's stuff, that those were his drugs and his guns. Does that make sense? especially the use of security and other conditions offered above. Okay. Young Thug is not a significant risk to commit a crime. He is also not a significant threat to the community, property, or person insane. All right. See Williams v. State. Next. Young Thug is not a significant risk to immediate witness or otherwise obstruct the administration of justice. Now, again, I don't think Thug should be in there, but if we're going to be fair and we're going to look at it from both sides, this might be where I disagree and where I could see he might not be able to get this bond. And we'll listen to what he says, but just seeing this note, that's my opinion on that. We'll see. Young Thug has suggested a condition of bond that all of his calls, text messages, and other means of communication are not monitored, save privileged communications. And additionally, he will be secured in his home when not present in court. This will prevent any possibility to intimidate. Oh, I read that wrong earlier. I apologize, y'all. To intimidate a witness or otherwise obstruct the administration of justice via electronic means. In today's times, the legislature has provided that ankle monitors are a humane method of incarcerating a criminally accused without the need for punishment that is endured by languishing in the county jail, punishing someone who is innocent because they haven't been proven guilty. The honorable court's foremost consideration with fixing the amount of bail should be the probability that Young Thug, if granted bond, will appear at trial. Young Thug is a respected high-profile artist who has positively impacted lives of others who would otherwise never break the poverty line. And it's interesting because you see, was it the Danza Project interview that Lil Woody did? He actually mentioned that. He mentioned how Thug helped him see how life could be better. How Thug helped him see that he didn't have to be in the streets and he could be successful, and that there was another part of life besides running the streets or doing whatever he does. So this is a great point by him. He is highly respected, high profile artist who has positively impacted lives of others who would otherwise never break the poverty line. This is true. Young Thug has made tremendous positive impact in our community. Young Thug is a positive member of society. He will continue to lawfully and ethically fight these baseless charges governed by the above facts and law. Young Thug satisfies all four prongs of A versus state. Young Thug satisfies these four bond factors, and thus the burden of production falls onto the prosecution, and the prosecution always retains the burden of persuasion that there are no conditions of bond that can be crafted to permit Young Thug to be entitled to pre-verdict release. Okay, so Brian Steele didn't spend too much time on this section, and as I mentioned to y'all, I think I know why, but he makes a good point. If I'm the prosecution, I'm gonna spend most of my time on point 4. Let me see here. See, Dunn versus Edwards. In our society, liberty is the norm. Custodial detention prior to verdict is carefully limited to few people. Indeed, the most important element of liberty is to be free from physical detention by one's own government. Based upon the above, Mr. Williams, aka Young Thug, must be granted a reasonable bond with the conditions of the same. Wherefore, Young Thug respectfully requests a reasonable bond be set by this honorable court with reasonable conditions of the same. Respectfully submitted by the Attorney of the Year, Brian Steele. All right, this is a simple question I have for y'all in the chat and in the comments. Is Young Thug gonna get bond? Let me know what you think.